go ahead and talk about,
Okay.
if you guys want to proceed that way. Okay, the first one is Article 9, grievance procedure. You all proposed extending first of all, we're changing any reference to lieutenant, we're changing that to commander, just to be consistent with the titles are currently in the pay plan. On page 2 of that proposal, you all proposed extending the time frame for steps 1 through 4 from 7 days to 14 days. We are proposing 10 calendar days in each one of those steps. We understand you need a little more time to consider holidays, days off, that sort of thing, but we also have an interest in trying to get agreements filed as timely as we can, while events are still fresh and we can still get, witnesses and documentation and that sort of thing. So we're proposing 7 days I'm sorry, 10 days, 10 calendar days for each step. The next one is Article 12, wages. This is consistent with your proposal to strike 12.3, which makes a reference to the effective date increase in 2017. So that's language that we don't need any longer. On Article 26, discipline and discharge, you all proposed some additional language related to policies, collective bargaining agreement, past practice, and due process. Our proposal is status quo. We're proposing to not make any changes to 26. Reason being, in 26.5, you already have some limitations in there on the chief's authority to administer discipline, consider the severity of the offense, the number of offenses committed, and the officer's performance record, prior discipline, prior commendations, and other mitigating or aggravating factors. So we don't think that additional language is necessary. As to the due process, or just cause language that you all proposed, I wanted to point out that in management rights, 3.3, we already have a provision in there for proper cause. It says the chief may discipline for proper cause. So we think that to put it back in this article is not necessary, it's redundant, and you already have those limitations included in the collective bargaining agreement. And Appendix E is the drug policy. You all proposed striking 2 references to blood tests. And again, we are proposing status quo on the drug policy. Steve, you pointed out that you need a court order for a blood test now.
Usually you would require a search warrant.
Right, unless there is an agreement in your collective bargaining agreement to include those. And so, from our perspective, we don't expect blood tests to be something that we would use frequently, or to my knowledge, we haven't required an officer to submit to a blood test at all that I can remember. But, be that as it may, we don't expect that to be something that we would utilize frequently. But we feel like it's necessary to leave it in there for unusual circumstances. Suppose there was an injury and we were not able to collect a urinalysis or a breathalyzer, wouldn't you want us to be able to utilize a blood test to verify that the officer is not impaired, for instance?
Well, if he's incapacitated, you would definitely have to have a search warrant, unless it's a DUI where there's probable cause and then apply for everything. You couldn't just do a forced draw, even under the contract if he's incapacitated. Because even, having the opportunity to right to refuse, it might end up in termination, but at least they have that recourse. Incapacitated, they do not.
So incapacitated, you're saying you could not use a blood test
I
at
would
all?
say you could
Obviously,
not
you
forcibly draw it.
can't get, authorization from an individual who is incapacitated.
I mean, put yourself in that position, you know, you get in a car crash, and unless they suspect you of DUI, sometimes they have to have reasonable suspicion of probable cause. They can't do the blood draw forcibly under implied consent.
Right. But
Otherwise,
if we
you're-
have this agreement in place that provides for blood tests, we could
So
take a
you-
blood
do
draw
you-
with suspicion. And
What's,
again,
what probable
wouldn't
cause?
wouldn't you want us to be able to draw blood to verify that the officer was not impaired in
So,
those situations?
but blood is, we talk about redundancy, the same chemical analysis can be garnered or gathered from breathalyzer and urine for the presence of alcohol and or drugs, you know, depending on the test. Blood is just, I guess, the way we look at it, again, we work from the criminal side of things. The way we look at it is blood is invasive. I have to go take your blood. However, my breath and urine are waste products. I can give those to you. And that's, you know, so blood gets it all, but it's something you're taking rather than, you know, us giving.
And urine covers everything too. Just like in DUIs, you store the urine, set it off in a spectrum. I mean, it tells you everything, drug concentrations that, you know, you enumerate by statute what you're looking for in DUIs or under the impairment. You know, it's not just drinking, obviously, but all that stuff's listed, and that's what they test for in urine analysis. You can do the same with your urine. You don't have to have the blood. It's redundant and it's invasive. And it's probably a violation of constitutional rights.
Not if it's agreed to and neglected.
Well, that's true too.
Correct, but the city
not
also
each
has-
individual.
City also has a little burden of proof. You guys only have to prove reasonable suspicion. If I want somebody's blood, I have to go to that probable cause for it.
So that's
it's a
the reason
lesser-
that you're proposing to strike it is because,
It's redundant, number one. It's a test that does require, you know, sticking a needle in somebody's arm or to a waste, products that get the same information. And like Steve said, in the event that somebody's not able to refuse, again, that they could be held to any sort of termination or whatever discipline is already in this agreement if they refuse that blood, that breath, that urine. But we don't like the thought of, you know, signing something that says even if they're incapacitated, you could take their blood. For a much lower burden of proof than we're held to at reasonable suspicion rather than probable cause.
Protects the city from, you know, litigating this matter, to be quite honest. I mean, that would be on y'all, not on us. And that would have to be,
Litigating.
yeah, if a person sued.
you mean, if in the event that we used a blood test,
If you perform the blood test
if
and
we
report
performed the
these
blood
results.
test, even though you've agreed to it in the collective bargaining agreement,
I
you
would
think it would
think
go to
we could.
litigation?
I think an individual could. The union may not do it, obviously, but an individual could. They could even sue us. I don't know. I mean, just think about, you know, well, I didn't vote on the contract even though it covers you, or I'm not a member of the FOP, so I didn't vote on it all. I mean, he's not agreeing to it, he's just covered by it, but that's part of being in a right to work state as opposed to a union state too, so. It just.
So they may
Just
argue
seems
an
to be a mess.
individual right that withstands any contractual agreement.
Are y'all seeing things across the state where this is kind of coming up?
Well, there was actually a case in Miami, and this isn't defending the officer because he's totally wrong, but this is the type of thing that could come up. An officer was in a traffic crash, but he was outside the vehicle when it occurred. Policy requires if you're in the vehicle, they're gonna do your analysis. Your analysis came back with positive for cocaine. After some litigation, that was suppressed because it's a violation of their policy and procedures to take your analysis without probable cause, reasonable suspicion, if you're not in the vehicle. So, you know, he was part of a side road system, motorist working a crash. However, you couldn't suppress the fact that he tested positive. Now you've got an officer who's tested positive. Now it's a CJSTC event because that's a mandatory subject of report, just like lying, sex on duty, you know, excessive force, those types of things. So it created a conundrum down there, but I know that's a little off, but you know, those are the types of things that go on. And why would you wanna even put yourself at risk for that? So, like I said, it's redundant. There's really no need for it. If you have some type of probable cause and it was outside the contract, you still get a warrant to do it, that'd be the proper way to do it anyway. You already have administrative blows, they can't refuse, you got, you know, your analysis, and you can scream for whatever you like, for whatever's in the drug policy.
I guess I'd like, under what circumstances, what if this to death, under what circumstances would you use a blood draw? That, as they're saying, you can't get the results you need from a urinalysis or a breath test.
I imagine, I mean, like I said, I don't think it would be used very often, I don't know that we've ever had to use blood tests.
Then why have it in the language?
Well, just in the event that for some reason we were not able to get a urinalysis or a breathalyzer, then you would want the option to use a blood test to determine impairment or.
And in workers' comp, they'll take blood draws.
Mm-hmm.
In workers' comp cases. In different departments.
Well, maybe enumerate that, in the worst case, consider, listing circumstances that a blood draw would be requested or required, instead of just having that option.
Because the current side of things, we have to prove that a blood and or urine test were impractical. That's one of the things that we have to say, so before we get to that, again, invasive test rather than the waste test, we have that burden to show. So, I don't think we'd be opposed to putting specific, you know, reasons why blood versus breath and or urine.
Okay. Chris, did you have any other?
No.
Okay, so we can look at whether we might wanna revise language in the proposal.
Mm-hmm.
Yeah, just to kind of, rather than keep it as open-ended as it is, I mean, there may be a time when blood is the only practical available method to be able to test for the presence of alcohol or drugs, but, you know, we wanna make sure that the first two are exhausted prior to, you know, blood testing requested, demanded or included.
Okay. Does anybody have any more questions or comments on any of the other proposals that we just talked about?
I don't.
You okay with this article or no?
I mean, I think 10 is something that I'm agreeing with, and obviously 14, but I understand the exclusion, so.
But the argument for their reason was to keep it consistent with what management had. Step one, it is the same, but management has 21 days going after that, 45 days after that. To do what? I mean, you know, what do they need the extra time for? I mean, would be our question.
Would you guys be
Typical.
willing to shorten your time?
We would consider a proposal, yeah. Yeah.
Would, I mean, if we all went to 10, would that be amenable?
All three steps?
10 days on all three steps, we'll have to look at it.
I would say no.
I think I'm not, definitely not on.
On 10 for us.
Uh-huh.
Yeah, that's too short. It's so difficult to get anything like that developed in 10.
Well, then, can we ask this, whatever you guys request, and we just match? I mean, cause you have the same research, you have the same meetings, and obviously, we have from our end. If you guys are willing to come down to your time, and then let us meet the same time frame, or give us the same, afford us the same time that you guys are giving yourself, I don't have any problem with that either.
I mean, everything, pretty much your investigations are handled when it gets to the city manager level is to the point where he makes a decision and it can go to arbitration either way anyway, so, I mean, that's about as far as you can take it anyway without having, you know, both sides have attorneys involved and having an actual hearing.
We'd have to talk about that. I do, think that we would require more time on our end because we have to consult with potentially labor attorneys to you know, whatever the case may be, we have, whatever the circumstances are.
But we would have to do the same.
We would have to consult with HR, with legal, and for you to file the grievance initially, I don't imagine that you would need as much time. I could see potentially they would have to consult with you, but, I think it may take us a little bit longer to develop our response on our end. But we would consider revising some of the timeframes if it makes sense. We can get together and talk about that, Chris? And we also wanna look at our other policies, other collective bargaining agreement and personnel policies, and see if we can find some consistency in there in our timeframes, just for administrative, ease.
Because don't forget, you have the 180-day rule, and, you know, from the day, the inception of the investigation till its conclusion, which would be to the point of the, city manager's decision, if we went that far. You'd have to meet those guidelines, if you're talking 45 days or 21 days, you're adding a month, you know. And then you have time for response after that. If you run out of 180 days, then we went automatically by default, so.
Okay, yeah, we'll look at it.
Okay.
Was there anything else on any of those?
26 is the other one.
What's that?
Yes.
26 was the just cause.
The termination, just cause.
Yeah, she says in management, it's
I didn't see the word just cause in there.
Proper cause in management rights, it says.
Proper and just are two different things. Proper, either like procedurally or whatever, just cause is an accepted terminology in, discipline, number 112. And, you just can't discipline willy-nilly cause. It has to be for just cause. It has to be an actual articulable event that you can, justify taking action on an officer for.
And how is that different from proper cause?
Well, I mean, proper cause can be applied to a civilian, because they don't have to have just cause, they're not covered by any statutes, we are.
But in management rights, if we're not talking about
No,
civilians.
and the C-112 trumps management rights in that respect anyway. So it's just best just, you know, to come to a happy medium there, because it doesn't take anything away from y'all. If you're doing things right, you'll do it for just cause anyway. But the language ensures that, and it gives them that ability further.
And I know we talked a little bit about this, you said that this was not triggered by any particular
Nothing from here.
event or circumstances in your department, right?
And that-
Just that you've said that it comes up in some other PDs on occasion?
Well, it comes up mostly in sheriff's office, because, you know, and I don't mean this to be disparaging to anybody in particular, but there's a lot of sheriffs across the state who come from strictly rural type places where, you know, the family's the judge, the family's the sheriff, the family's the mayor, those kind of places, and they pretty much rule the way they wanna rule. And unless somebody stands up to them or, you know, takes action, you know, pursuant to 112 for the officers' rights, they don't have that. They just pretty much do what the sheriff does, because he hires and fires at will a lot of times, absent a collective bargaining agreement. The 112's there regardless. And that's just, you know, proper language, you know, should be in there. It shouldn't be a burden to y'all.
So really what we're talking about is referencing chapter 112,
Basically.
incorporating by reference, which is, we're already bound by chapter 112, right?
So a statutory reference or a statutory definition for that?
We'd have to see it just to ensure, but, you know, that may can work, but, I mean, just cause is two words, it handles everything. You gotta do 112 anyway.
Which is, I guess my point, if we're already bound by chapter 112, do we need to incorporate it into the collective bargaining agreement?
Well, if it's in the collective bargaining agreement, then there's no recourse on your part if you don't do it right. And nothing, you know, you can say, well, it's under management rights, well, you know, we can argue that and spend money litigating it and get the same outcome. If you had everything, you operate properly under the rules and regs the right way the first time, then you say all that. Not that y'all have been the issue, it's just one of the things that we're incorporating across the state and have been over the last couple of 3 years.
Can
And
you
if you
point
can
me
think of a
toward,
reason why just
toward
cause-
toward a collective specific CBA that we could take a look at, just see what the language looks like?
Sure, I mean, most of them just say, just can only be given for just cause, that's pretty much
Okay,
the way it reads.
could look at it.
Mhm.
Chris, you can look at that language.
Yeah, yeah, I'm looking at it right now, we can look at it.
Okay. Anything else on those articles?
That was it, me.
All right, I wanted to talk about all of the articles that you all proposed that have some lead provisions. And these are all of them. So I'm considering 11, 14, 15, 16, 20, 21, and F as sort of a bundle proposal that all of your proposed changes relate to lead. And your proposal that would have us combining all of your lead into one lead bank. We took a look at it. There is a pretty significant economic impact to those proposals. You all would have, the lead banks combined into one. It would be an hour-for-hour conversion. And in each one of these proposals, you would be raising the amount of lead that you can hold or accrue on the books and get paid out for. And so there is a cost associated with that. And any time you're banking more leave and paying out upon retirement or even paying out annually, you know, you're increasing our long-term liability for those retirement payouts. And if we're paying out leave annually as opposed to having it expire, naturally there's going to be a cost associated with that as well. So with that being said, we have had some discussion about potentially visiting whether a PTO plan makes sense, but we want to consider it holistically for all of our bargaining units and our non-union personnel. We want to look at it when we have time to really consider the long-term impacts, consider what the market is doing around us, and consider what the conversion rates need to be. In other words, would it be hour for hour? Would we increase the lead banks? Would we require certain criteria to be met before we allow for any cash out, rollovers, that sort of thing? And so frankly, we have not, you know, had the luxury of time to invest in that, and that's something that we want to revisit maybe in another couple of years. If we can get this agreement done for a 2-year period of time, we would be willing to come back and discuss it in a couple of years. I will tell you when the city manager was negotiating his contract, we offered him a PTO plan, and he said no. You know, I don't want to accept a leave bank or an accrual of leave that is any different from what all the employees are doing. So he feels very strongly that we need to really take a look at what makes sense for the entire city administratively, that we can actually manage a little more clearly and write some real clear policies to govern. Do we want to grandfather in some of the people who are currently in the sick and vacation? Do we want to roll everything over? We just need more time to consider all of that and how it would impact the entire city. So for that reason, all of these proposals that I just handed you, we're proposing status quo.
Have you incorporated, the MOU language about workers' comp not counting against, overtime for the purpose of making a full work week or whatever? You remember when,